Hello, in this presentation, we shall be looking at dissolution of marriage with respect to living apart provisions, the living apart provisions of the Matrimonial Causes Act of Nigeria. And I would enjoin you to subscribe to this channel and to also share the link. We've already started the discussion on the dissolution of statutory marriage by looking at some of the provisions of the Matrimonial Causes Act in section 15. And we had established the fact that there's only one ground for dissolution of a statutory marriage, which is the irretrievable breakdown of the marriage. So today we are looking at another fact that establishes the component of irretrievable breakdown of marriage, the living apart provisions under section 15(2) of the Matrimonial Causes Act 1970 of Nigeria. To do that effectively, we'll look at the provisions and look at the elements of that of section 15 with regards to the living apart provisions. I must mention that these living apart provisions are they are two forms. You look at it in the context of the 2-year living apart and the 3-year living apart provisions. So this the learning outcome regarding this presentation is that at the end of the presentation, you would be able to understand the meaning of the living apart provisions of the MCA and also identify the elements of the living apart provisions. And you'll be able to distinguish the 2-year and the 3-year living apart provisions from each other and apply the various concepts accordingly. The provision of section 15(2)(e) of the Matrimonial Causes Act of 1970 provides that the marriage can be held to have broken down irretrievably where the parties of the marriage have lived apart for a continuous period of at least 2 years immediately preceding the presentation of the petition, and the respondent does not object to a decree being granted. So those components have been highlighted. Living apart, they've lived apart, continuous period of at least 2 years, immediately preceding the presentation of the petition, and the respondent does not object to a decree being granted. The provision of section 15(2)(f) also provides that the marriage would have broken down irretrievably where the parties have lived apart for a continuous period of at least 3 years, immediately preceding the presentation of the petition. So one says 2 years, provided the other party does not object, and the other one says 3 years without any room for consideration of the other party. Now, the elements, first, that they must live apart. The living apart must be continuous for a period of 2 years. It must be unbroken, apart from the room that the law has made for possibilities of reconciliation that we'll be mentioning later. It must be a period that immediately precedes the presentation of the petition, and there's non-objection. So for the 2-year provision, that is what you have. Now, we'll be looking at living apart shortly. But let me just mention the fact that it must be a continuous period of 2 years preceding. So if you are bringing your petition on the 8th of January 2023 or 2024 or whatever date you are bringing the petition, you must count backwards for the last 2 years immediately before then. If there is any break, it's not likely to meet the requirements of the provision. And the law says that the other one does not object. So we'll be looking at these components shortly. And the 3-year provision, it's also the same. The only difference being that the provision about non-objection is not available. So these are the elements. Now let's look at this time that we are talking about. It says, one says continuous period of 2 years. The other one says continuous period of 3 years. So you must take note of that continuous, that it must be unbroken. However, under section 17(2) of the Matrimonial Causes Act, the law allows or gives room for short periods of living together, which do not exceed 6 months, either a whole period of 6 months or 2 or more periods not exceeding 6 months, whereby the parties will live together and in order maybe to promote reconciliation of the parties. This time will not stop the petitioner from relying on the sections. So the fact that they ask a week, 2 weeks, a month, provided it doesn't exceed 6 months of living together, will not preclude the bringing of the petition. Time will not cease to run. So that is the provision of section 15.2 of the Matrimonial Causes Act that we had also examined during the discussion on desertion. Now, living with each other. Section 17.3 says references to this section to the parties to a marriage living with each other shall be construed as references to their living with each other in the same household. The elements that we should focus on in the living apart provisions are that there is a physical and a mental element involved in the idea of living apart. It is not just sufficient to say we are living apart. Physical separation is not the only component. The law requires that that physical separation has a mental element attached to it. In Santos and Santos was said that it is necessary to prove something more than the fact that the husband and wife are living apart or physically separated. Yes, physical separation is the easiest way to show that they are living apart, but it's not sufficient to just show that they are physically separated. The relevant state of affairs does not exist while both parties recognize marriage as still subsisting. So if the parties are living physically separated, but they recognize that their marriage is still subsisting, this element, living apart provisions will not be met. It is required that at least one party believes that the marriage has ended. So what is the meaning of living apart? I said we are going to look at that. Now, in living apart, for instance, if they are physically separated, the law requires that at least one of the parties, it may be both, but at least one of them must regard the marriage to have come to an end. So if one person leaves to go for further studies and they believe that they are still married to each other, no matter how long they are living apart, that will not be living apart to constitute a breakdown of marriage. Someone in practice is usually a case where someone that left in circumstances that shows that this person has moved out and is moving on for good. This person could be the petitioner or the respondent. In the living apart provisions, it might be the person that has physically left, separated. It might be the person that has remained. Any of them could be the petition on the ground that they are living apart. So the person, if you remember in desertion, it is the deserter is not the one that is bringing the case for desertion, it's the person that has been deserted. But here, both the petitioner or the respondent, either of them could have been the one that has physically construed the marriage to have ended. And it doesn't have to communicate this to the other party. So when we are talking about living apart, we are saying where there is physical separation and an intention to end the marriage, to end the marital relations, it must be evident from the facts of the case. So you cannot just say because I'm living away, W is living away from the husband in that they are living apart, not for the purposes of the law of dissolution of marriage. Anyway, then it can be emotional separation and intention to end consortium. So the mental element, the reasons for their living apart is a major consideration in this regard. So there can be, if you look at the Matrimonial Causes Act, you will see this concept of living in the same or separate households. Section 15.3 says, for the purpose of subsection 2E and F, that is the living apart provisions, the spouses are to be treated as living apart unless they are living with each other in the same household. So implicit in the idea is this issue of living in the same household. It means, therefore, that parties can actually obtain a divorce when they are living under the same, if they don't maintain the same household. So it's not sufficient to say we are living in the same building, under the same roof, but do you maintain the same household? If they maintain separate households, despite the fact that they are living under the same roof, they will be held to be living apart. So in the living apart provisions, the law also uses the concept of separation from a state of affairs and not necessarily separation from a place to underscore the idea that there's a living apart of the parties. Now, so in considering separate households, the courts have held again that, look, there must be no evidence of communal life, no evidence that they are living as husband and wife. And even something as small as doing each other's laundry could be construed as living together as husband and wife, as maintaining the same household. We've looked at the case of Mansa and Fula earlier in previous videos, where the court said that when a couple that lived in the same house in separate rooms, but they shared their meals, but there was no other relationship between them, were regarded as living in the same household. So if the wife decides to offer to wash the laundry, for instance, because while they are living in the same building, it might destroy the concept of living apart. In a lot of situations, in most countries, is because people live together even when they are in a state of marital breakdown because of many reasons. Maybe because you cannot get a house, or because you are still waiting to work out the separation agreement, or for some other reasons. So the idea, we must take note of this separate household concept. The section 15(2)(e), which says that they live apart for a continuous period of at least 2 years, creates a sort of caveat and says, look, you can grant divorce once you prove this living apart as construed by law, but you must establish that the other party does not object to the petition. The living apart provisions are the true no-fault divorce provisions. We have looked at other ones, and you could see from those ones like desertion, like behavior, like adultery, that these are fault-based divorce, even though we talk about a new regime that is not based on matrimonial offense principle. In the living apart provisions, therefore, the 15(2)(e), the 2-year living apart, requires that the other party does not object. If the other party objects to the petition being granted, then you will not be able to rely on this 15(2)(e). The party will show that he or she is not objecting in many positive ways, can fill and file the prescribed form under the Matrimonial Causes rules, and acknowledge service of the petition and answer that no to the question, do you intend to defend this petition? If it says no, that means the person does not object. Or you file an answer and a cross petition for divorce, or the person can state in writing that they did not object, or appear in court physically and orally testify in open court that they did not object to the petition. There are issues about other forms of non-objection when the person does not show up at all, when the person does not defend the suit, whether that constitutes non-objection. There have been different perspectives to this, while some courts have held that, look, non-appearance is evidence of non-objection because you have a right to come and defend your cause. There are concerns that sometimes non-appearance may not be deliberate, and so it should not be construed as non-objection. Be that as it may, we may conclude that under section 15(2)(e) and F, the living apart provisions allow the court to grant divorce that we can call no-fault divorce. And what they do is that the party proves that they've lived apart for a continuous period of at least 2 years, immediately preceding the petition, once the other party does not object, or it establishes that they've lived apart for a continuous period of 3 years, irrespective of any objection. The 3-year living apart provision actually is the true no-fault divorce, because the right person, in fact, you can divorce an innocent spouse under that provision. We'll be looking in the subsequent video the distinction between the desertion provision and living apart provisions, and we are going to emphasize the fact that the living apart provisions are the true no-fault divorce provisions. So if you just come to the court and establish the living apart provisions, the court really has no discretion. We just have to grant the petition based on the facts that are established, unlike other provisions of the law that deal with components of fault, where the court would say that there is no fault in this respect, and therefore they will not grant the petition. So that is the essential formulation of divorce or based on living apart provisions under the Matrimonial Causes Act of Nigeria 1970. In the next presentation, we shall be looking at other components of irretrievable breakdown of statutory marriage. Don't forget that we said the MCA applies only to statutory marriage. It does not apply to other forms of marriage under Nigerian law. Please don't forget to like, share, and subscribe to this video.